The broadcast is now starting. All attendees are in listen-only mode.
Well, we are going to go ahead and get the broadcast started. We're not going to start until noon because that's when we told everyone to start. But we wanted to give everyone a chance to adjust their audio, get to make sure the video is working, all that sort of stuff. We found in the past that people had to download things or work on those issues. And so we're going to leave these first 5 minutes just for you to make sure everything's working and let you know that we are indeed here and we will start at noon. In the meantime, and I'll introduce Sarah at noon rather than try to do it twice, but did want to thank everyone for coming to attend, both legal services employees and our private counterparts. Excited to have you all here. I will say that glad to present this from legal services with the help of our VLP partners. Legal services is the free legal services around the state for low-income people. And I wanted to encourage all the private attorneys to either sign up or always check in with your volunteer lawyer program partners in your area. There are 5 in Alabama: the statewide program, Huntsville, Birmingham, Montgomery, and Mobile. That covers all of South Alabama. Make sure you register to volunteer, and hopefully you can help somebody for free. Not sure what the time is. I got a few more minutes. If you would like to register to be a volunteer lawyer and you're not sure what the most appropriate program would be, the easiest way to resolve that would be to go to the State Bar website. There is a link you can click on for pro bono services. And from there, they will route you to the appropriate person. You can easily volunteer if you live in one of the 4 cities that has a volunteer lawyer program. Feel free to volunteer for both them and the State Bar. The need is very great, and there are lots more people than we can serve in our capacity at legal services, and there's always a need for good pro bono lawyers. One of the reasons we're having this session is hopefully to educate people about landlord-tenant law and some of the things they can do. With that being said, the one note I will make, if you've attended former or some of our earlier broadcasts, is that we will not necessarily be taking questions because of the tech setup that we have here. We have Holly Ray, who you can't see off camera, the managing attorney of the Huntsville office, taking care of our technology needs and running the camera and stuff. But you won't necessarily be able to see all the questions. We will try to come back to them at the end. So if you have questions, go ahead and type them in the question bar. I will be circulating the materials. Someone always asks that, and yes, I will be circulating the materials at the end. But just be aware that questions may not get answered immediately. We do have people monitoring the sound and video, so hopefully that should not be an issue. And did you have any preliminary statements you wanted to make?
Nope.
No. Okay.
I think you're covering it.
We have about 2 more minutes. Hopefully, I expect most lawyers are either on time or early. If they weren't, they wouldn't be lawyers very long. But we'll give everybody just a few more minutes to log on. If you're just logging in, or if you're just coming to this is a session on landlord and tenant law. It's going to be very exciting. I think for the first time, and these are Legal Services Alabama's monthly webinars. We do one once a month. This is actually the January one, which ended up going to February. And I think we'll actually be doing February's on March 1st or 2nd too, so a little bit behind. But I think this is the first one we've had multiple presenters, and it's certainly the first one we've had different viewpoints, which I'm pretty excited about. I've already talked to Sarah, and I've said I think this is going to be our Region Kathy Lee event, or whichever your favorite Michael and Kelly or Ryan and Kelly or whoever your favorite version of that show is. But anyway, we have about 1 minute. Hopefully everyone's sound and everything is set. And hopefully everything goes well. Did you have anything, Holly, that you wanted to share with the world? Not really. Okay. Just to make a couple notes about the CLE credit. In order to get the CLE credit, when you registered, you would have had to sign up with your bar number. If for some reason you didn't sign up with your bar number, you can email me. It's mforton@ALSP, and just make sure you give me your bar number so I can stick it on the list. And then the second thing I will say is at the end of this event, before you leave, when you go to shut down, it should trigger a evaluation. Really appreciate you filling those out. It helps us know what we can do better, helps us know what your experience is like, and also please love hearing the new ideas for different things and knowing this event actually came from several people asking for a landlord-tenant event last time we did this. So I knew it was something people wanted. So that is why we're doing this one. So let us know what you're interested in and what you think might help. With that being said, we are 1 minute past time to start, so we can go ahead and start. Welcome to the Legal Services Alabama. It's a landlord-tenant webinar event. Glad you could join us. We will be here for about an hour, ending pretty promptly at 1. My name is Michael Fortin. I'm the Director of Advocacy at Legal Services. And to my right is Sarah Taggart. Sarah Taggart is an attorney in Huntsville, Alabama, whose primary expertise on landlord and tenant law,
yes,
and all kinds of housing law. And Sarah has graciously agreed to be part of the webinar. Do you want to say anything else introducing yourself?
No, except that we're statewide. So I'm familiar. We don't just practice in North Alabama, we're statewide.
That's true. And you actually do a fair percentage. I don't know if you know what the percentage is, like a third?
I've been told I filed half last year.
Of the evictions in the state of Alabama.
Yes, but I don't know if that's true or not.
That's
That's a lot.
That's a lot. That is a lot. A lot of fans out there. And for those of you who don't know, I practiced in Huntsville before becoming the Director of Advocacy. I practiced a lot of housing law, and so Sarah and I were kind of like Tom and Jerry, or the Coyote and the Roadrunner. We were talking before about which one was the Coyote. I'm pretty sure it was her with half of the evictions. But anyway, that being said, let's go ahead and get it going. The first thing we wanted to do is this event will actually go into a lot of different parts of landlord-tenant law. I think we both tried to come up with a top 10 list that we thought would be would hit on things we think people don't always think about when they think about landlord-tenant law, mistakes that we see a lot of, mistakes that a lot of landlords or lawyers and landlords and tenants make. But we wanted to make sure everyone had at least the basics down. So landlord and tenant law, residential landlord and tenant law in Alabama is governed by the Uniform Residential Landlord and Tenant Act. It's 35(9)(a). Almost everything that you hear us talk about today will be there, unless it's some sort of federal statute. As most of you learned in law school, because I think almost everyone attending is a lawyer, tenancy begins when the parties enter a lease. We will talk all about that a lot during our presentation. Generally speaking, landlords and tenants both have some responsibilities. I think landlords' basic responsibilities kind of keep the place decent, livable, keep utilities on, stuff like that. And tenants, pretty basic responsibilities as well. Pay your rent, don't cause a disturbance, don't destroy stuff. But that's it. And also, in case you did not know, hopefully anyone who would be involved in landlord-tenant law would already know this. But probably the most common, probably the two most common times that landlords or tenants come into contact with lawyers is going to be either drafting leases, the preliminary stuff, or the eviction stuff. That's when we see a lot of those. And you should understand, if you don't know already, you may want to go look at the act, that before you can evict somebody, you are required to give them a notice. There's different time frames. We're going to talk about some of those. There is specific rules governing evictions. There's different time frames than there are for any other civil cases. And that was my estimate. I think that in total, an eviction probably takes about a month or two from the time you give the notice.
We say 21 to 35 days from when the court gets involved.
Sure. So it's 21 to 35 plus 7, and I was also, is that what you think to actually get possession back, or to get an order?
That's until we get an order. Yeah. And sheriff wait times vary dramatically, county to county. That's absolutely true. But so with that being said, that's a brief overview. We started looking at the top 10s, and I realized some people may not know what we were talking about, so I gave that opening. But and with that, let's see what Sarah's number 10 thing that she thinks that you should know about landlord tenant law. Biggest one, easiest one to get at, a security deposit is capped at 1 month's periodic rent. You can certainly charge less than that for a security deposit. I don't know why you would, but you are capped at 1 month of periodic rent as your security deposit. That, of course, does not include any pet deposits that may be taken or prepaid rent, but the security deposit itself is capped at 1 month's periodic rent.
Right. And a lot of times, although that doesn't mean that you always see that, but there's a fair number of landlords who ask for fairly large deposits, but legally you can't do that. No. The one thing I thought that people should know, especially maybe landlords, attorneys, but if you're going to be defending tenants, one of the weird things we always discover as people start at legal services, they're shocked to find out that when an eviction is filed, there's almost always some communication between the clerk's office and all the various eviction databases out there on the internet now, so that by the time a case is filed, it almost certainly is going to be publicly, everyone who uses these databases is going to know, certainly within a week. I've had many clients come in and tell me that they found out that they were being evicted when they went to apply they're trying to move out, they go to apply to the next place, and when they go to apply, the new landlord says, hey, you got an eviction against you, before they've even been served. Not when Integrity serves them, because you get them you have the process server set up so well, but if they go to the sheriff, it usually takes up.
Yeah, the thing I always tell people, I actually training my landlords that when they're looking to do screening, the best piece of advice that they can do is to go to the local courthouses in their county and try aliquot. Because I say that aliquot is instantaneous. The evictions that I file that morning are already in there. So you can find the tenant that's looking for a house or a new place to live that's being currently in eviction.
So it does appear pretty fast, which sometimes leads to the problem of if someone's trying to move out of one home into another, which is ultimately I think what the landlord wants, who's trying to evict them. They want them gone. Sometimes that's a problem. No one wants a tenant who's being evicted right now. But anyway.
Sorry, we're reading, or I'm reading. So it's important when you are going to start an unlawful detainer action that you actually read the lease that the tenant entered into, because the lease operates as the intersection between the lease and the Landlord and Tenant Act. The lease can give a tenant more protections than state law. So while state law is going to generally give a tenant 7 business days, which we'll go into a little bit later, to pay the rent to avoid eviction, your lease could be drafted to give a tenant 14 days, or your lease could be drafted to give a tenant 30 days. If your lease gives the tenant more protection, you're going to be bound by the covenants that are in the lease and not by what state law says. So it's important before, as a practicing attorney, before you file the eviction and just use what the statute says, that you actually read the contract between the parties if there is one.
Right. And I will say that as a legal service attorney, the very first thing we ask everybody to do is, if you have a copy of your lease, bring it in. We go through every paragraph trying to see if there's any additional protections, any kind of random things that people decide to.
You see people that have downloaded leases from other states that they're using just off the internet, or you guys see people that have leases that are out of compliance, that have that predated some changes to the Landlord and Tenant Act. So the most common ones I see is like security deposit accounting letter. State law now says 60 days, but if your lease says 35, you're stuck with your 35-day cap. So where that 14 days, it used to be a tenant for all other violations besides rent had 14 days to fix the violation. Some leases will still say that, even though state law now says 7.
Yeah. Well, I think this is exactly why if you're going to be a landlord, it's important to go talk to an attorney. I do see a lot of landlords who try to do things in the cheap and draft their own leases, or especially find something out. When you find something off the internet, you get what you pay for, and then quite often, you as an attorney, if you're filing an eviction, or you as an attorney if you're defending an eviction, gotta go back and look at that lease, because unless you drafted it, and you draft your own for your clients, but unless you drafted it, you're not going to know what's in there, and it can either help you or hurt you depending on which side you're on. So, I always throw this in when I talk to landlords or tenants or lawyers about landlords and tenants. It's important to remember that not every tenants are neither good nor bad, and landlords are usually neither good nor bad. Maybe some landlords are bad, but tenants are neither good nor bad. Then there are different complexes, there are different tenants. As a landlord, you need to screen your tenant. You need to do the background check, whatever you do, to know who you're leasing to. And as a tenant, you also want to know what kind of complex you are moving into. If you are a quiet person who likes to go to bed at, lights out at 7, asleep by 9 o'clock, you might want to stop by the complex you're looking to rent at and 10 o'clock at night one time just to see what's going on. Because I think the complexes the landlords have, they're very different. I've been a renter for many times in my life. When I rented in Tuscaloosa when I was a student, there was a certain state, everyone was really loud, and that was kind of expected where I rented. And later when I had a child and a wife and was in a nice residential complex, it was quiet. And I think part of that is, for both sides, landlords especially, you are going to avoid 99% of your heartache, I think, by doing good background screening checks, by knowing if they've been evicted, knowing if their income is, that sort of stuff. And then on the other side, tenants, if you are the kind of person who, if you're the kind of person who knows you're probably going to be up late making noise, you probably should know that not every complex is going to be the best one for you. So
I always tell people it's a relationship, and just like any relationship, sometimes it can turn toxic. Usually by the time I'm involved with the situation, the parties are not in a place where the relationship needs to be saved. Like, both parties are sort of done with each other. But I agree with you. I think a landlord that takes the time to not just ask the questions to the tenant, but actually do the background research to verify that the tenant's being completely honest. I think those landlords save themselves a little bit of pain and suffering on the back end. No,
and just like most bad relationships, they probably should never have started. If your personalities don't match, which again, I still think there are complexes that have more lenient policies about noise and just traffic. Not necessarily that they don't care, but they're more or less understanding based on where they're located, what part of town they're located in, who's renting there. You want to find the complex that makes sense for you, and definitely the one that's within your price range. Otherwise, you certainly will see, Sarah, if you decide to step out of your price range.
Okay, tenants with disabilities have the right to request accommodations or structural modifications or reasonable accommodations under federal fair housing law. So now we're not in the state Landlord and Tenant Act, we're in the federal Fair Housing Act. But the one thing I want to point out to landlords is that, or attorneys that deal with this sort of situation, is that the right to an accommodation is not absolute. The right to an accommodation contains a reasonableness prong to it. So a tenant with a disability is not entitled to everything that they might want. They're only entitled to accommodations that are deemed reasonable. So I see this a lot with emotional assistance animals under federal fair housing law. There's one, saw a news article where a guy wanted an alligator, emotional assistance alligator. While he certainly might have a disability, while that alligator might in fact help with his disability, there's that reasonableness prong that will allow most private landlords to say no to that particular accommodation.
One second, and go ahead and click on the orange arrow just to see. The orange arrow at the top, yeah, you got it. Yeah, it should be correct. Broadcasting video. Send it back out. 1 second for technical check. Hit the orange arrow again. I believe it's, I think it is broadcasting video, Holly. I'm not.
Okay, there was somebody that texted me that they couldn't see it, so.
I will say, we got several people to let us know if there are any problems. You should be seeing us by video. If you are not, if someone let me know, we'll try to fix that. But we believe that video is working. Otherwise, we've been sitting here looking at the camera, making great animated faces for no reason. Another thing about the Fair Housing Act, there's a large body of law about it. It's a pretty,
So webinar for another day.
Yeah, sure. But the one thing, not everyone is absolutely covered by the Fair Housing Act. There are some exceptions. If you only have 1 or 2 units and don't use a broker and don't use and are just kind of a very small mom and pop, you may not be covered by that. But almost everybody is going to be.
I will say in my practice, I have never advised a landlord that they are not covered by the Fair Housing Act, because there's always these little ways that the HUD can get jurisdiction, and saying the Fair Housing Act doesn't apply to me is like waving a red flag in front of an angry bull. HUD's going to find a way that it applies to you. So I always say that you might as well follow the protections of fair housing, even if you might qualify for one of the exceptions, because it's just easier that way. And it's, I think, best practices to advise a client to follow fair housing law, even if they don't particularly need to.
Well, and I think legal services position would be, when it's just requesting that everyone be treated fairly and without bias. I mean, it's also probably just the right thing to do. And I will say that probably the vast majority of fair housing cases we see are the reasonable accommodations. It covers race and religion and a whole bunch of things you can't discriminate based on. But the issues that always come between landlords and tenants are if someone has a disability, what the landlord has to do to accommodate them, especially the animals. The next thing I wanted to mention was that quite often here at Legal Services, none of Sarah's clients, I don't think your clients don't try to pull this, but occasionally we will see a landlord who tries to write into their lease that it's a transient housing, or that it's, we have some motels in the state that used to be motels and now operate as basically landlords. They let people move in and stay long term. If you're truly renting at a hotel, if you're going to the Hilton, or if you're going to Super 8 or wherever, there's a whole different set of laws that apply to you. The hotel can probably ask you to leave at any time, very little notice. You just collect your stuff and the sheriff is going to take you off the property. Occasionally you'll find a landlord who lets people live there long term and tries to either, because the physical building used to be a hotel, or because they write it into their lease, they feel like they have the right to just remove you without process. Skip the eviction, skip all the rights and responsibilities of landlords and tenants, and just be a transient housing or hotel housing. There's at least one case in Alabama that says that's not the case. It's the Stackhouse case, which is cited below. And there's also a whole body of law around the country that goes into whether or not someone's transient. And they go into things like, well, is this intended to be your primary residence? Are you ever made to leave if you stay for long periods of time? Obviously, it's your primary residence. Do they provide sheets and bedding? Do they come in every day? There's a whole bunch of different small tests. But the basic rule is, if it is somebody's home, if it is their primary residence, then the landlord-tenant law is going to apply regardless of what the lease says, regardless of what the building looks like. And then they're going to get all the rights and protections of a tenant. They're going to be entitled to an eviction. They're going to be entitled not to be locked out. the sheriff can't come and remove them on an hour's notice.
I say that this also, the blurry lines, I see this mostly in South Alabama with the short-term condo rentals. And at what point does short-term condo rental become a full-fledged tenancy, entitling the tenant to the protections of an unlawful detainer? It's not as cut and dry as Stackhouse would have you believe, because you've got some police officers that are trained to say that somebody establishes a tenancy just by getting mail somewhere. Mm-hmm. And I know, it's great. And so the line on when it's a transient housing and when it's an actual sort of landlord-tenant situation, it's really sort of blurry. I think it's more blurry than even you realize.
Oh no, the one case that comes to my mind is that we once had a tenant who lived at a hotel in Madison, but then stayed there for 2 years. They never made her leave her room. They knew they knew that that's where she lived. And
pretty sure I was on the other side of that eviction.
that was clearly, to me, every other unit at that hotel or motel was transient. Everyone else there was renting for a week or a day and then in and out. But we argued and at least prevailed to the extent that she was recognized as a tenant, that, once you let her move in and live there for a long, long time, what can oftentimes look like a hotel is not a hotel anymore. Yeah. Transient.
With conduct-based evictions, the Landlord and Tenant Act doesn't give a standard of proof required when a landlord is alleging a tenant's conduct is the basis for the eviction. So you have your non-payment cases that's pretty straightforward. Has the tenant paid? Has the tenant not paid? But when you have sort of a drug case, the tenant's engaged in drug activity, or you have a case where the tenant has an unauthorized occupant, it does not say in the statute how much you have to prove that. So that I have found in my practice statewide that different judges have different interpretations of the standard of proof that's required for a landlord to prove that the tenant's engaged in this conduct. I've actually had on drug-related cases judges that have said nothing short of a conviction will result or will support a drug-related eviction. But then I've had other judges that have said that my burden is preponderance of the evidence, that I just have to prove it's more likely than not that they're engaged in drug activity. So that's sort of until we get a proof requirement written into statute, which I don't see happening anytime soon. You just need to sort of prepare your clients for the fact that the court may surprise you with the amount of evidence that you're going to need to win a conduct-based eviction.
But I feel like that's just almost that's a small slice of a larger pie, which is that anytime you go to court with these, judges each have their own.
I always tell people it's supposed to be a statewide act that's uniform throughout the state, but it's different in every courtroom and in every county. They all have their own customs. They all have their own requirements for what they want for a default. They all have their own requirements of what they're going to require to have you prove your case. It's different in every courtroom.
Thank God. It must make your job hard.
I mean, it's you get used to it, but I have actually had similar facts and a trial at 9 and a trial at 1:30 and gotten a different answer in the same county, just depending on whose courtroom I was in.
I think we all know that sometimes even the same judge
will give you a different answer. And so I would certainly love written into statute to be drug activity related evictions don't require convictions. That can just be, I'd like the standard proof to be written in, and I'd certainly like it to not be beyond a reasonable doubt. But I don't see that happening anytime soon. So it's really just a question of figuring out your bench, but preparing your client for the fact that when you go to trial, quite honestly, there's no guarantees on what a judge is going to do, even if you have a slam dunk of a case.
Did I just mishear you? Did you say you hope it's beyond a reasonable doubt?
I hope that it's not
okay.
Beyond a reasonable doubt.
Must have misheard you, but we will go back and edit that post to make you say what happened. Holly. This is something that's come up from time to time with legal services lawyers around the state. different judges. One of the fun things for you, I'm sure, is the rent posting requirement. If you lose an eviction in Alabama, the tenant wants to stay in the unit, then the court is supposed to set the amount of rent that's come due since the case was filed, and then set an amount to be paid in the future as if the tenant stays there. So that if an eviction was filed, we'll say January 15th, then, and the hearing is until March, then the court would set the original payment for February and March's rent, and then say in April and May how much they should pay in. That's the law, and definitely you have to pay to stay in the house. The issue we've run into is that sometimes courts try to make that payment. They won't let you appeal anything, not the money judgment. And theoretically you could appeal the eviction. I'm not sure why you would if you're not staying there. But there's even a statute that gives you the right to go back, and if you win later, although I've never actually known anyone to do that.
Never seen it.
But you should know that if you're going to take one of these cases or defend one of these cases, that the payment of rent is necessary to appeal. But that won't stop somebody from appealing money judgments. Do you disagree?
Well, so the thing I get is if they don't post the rent into court, we do a motion for failure to meet a condition precedent of the appeal. I have never seen someone appeal me on an unlawful detainer. I see them appeal and not post and try and stay there, but I've never had somebody that's moved out and still appealed. Mm-hmm. I think that the only way we would see that is if you guys were on the other side and there was some sort of subsidy at issue. Most of the time, the only reason they do appeal is because they want to stay in the property. So I will say that paying the rent into court does mean that very few of these cases, I see maybe one appeal out of every 200, 300 cases. So it's not a very common thing.
Right. And I think the ones that do appeal, honestly, tend to be public housing where it's a low payment, where it's either zero or very low. Although, have you never seen any just appealing the money damages? Really? Wow.
I mean, I've seen most of my appeals come out of security deposit litigation, where people don't like the decision of the judge of the trial court on what happened with the security deposit. So I get a lot of those appeals of money awards, the ones where they don't think that they should have lost. But evictions, the only reason I ever see them appeal is because they want to stay. And the other thing on that is you can get some tenants will end up getting hardship waivers on they're supposed to not only post their rent into court, they're supposed to pay the costs associated with the appeal. Depending on your bench, some judges will let them get a hardship waiver on the appeal filing fee, but they cannot get a hardship waiver on posting that rent. That rent has to be posted into court for the tenants to stay in possession while the appeal is pending. Oh, it's me again.
Did you skip one?
Oh.
Okay.
I'm back to fair housing because most common things this is what I wanted. I think at one point I heard anecdotally that this was the #1 fair housing violation in the country, was charging a pet fee or pet deposit on a properly documented assistance animal. So back to fair housing and assistance animals, I spend at least every 2 or 3 days, I get an animal question of a tenant is buying something offline, saying that their dog, they got an ID card, it's got a picture of their dog on it, and it says that their dog is a service animal. That's not appropriate documentation under federal fair housing for you to make a reasonable accommodation to waive a pet fee or a pet deposit. Those little things, I actually had myself certified as a service animal. I dressed up like a cat and got myself certified. That's how rigorous these online sort of services are. So if you have a tenant that's trying to get away from a pet fee or a pet deposit, you got to realize that you need to have proper documentation. What is proper documentation for an animal to become an assistance animal under the disability prong of federal fair housing law? It needs to be a note from a doctor, therapist, medical professional, somebody in the position of providing disability-related services to the individual. It needs to indicate that the individual is disabled, which means that they have a physical or mental impairment that substantially limits one or more major life activities. And it has to indicate that the individual's animal assists with that disability. So it's not just that they're disabled as defined by the Act, the animal has to in some way assist with that disability, assist with letting them occupy the property. I also say that this note needs to be geographically reasonable, which means if the tenant just moved into your area from out of state, an out of state letter makes sense. But there's a guy in New Jersey, a social worker, that puts out letters all in caps, obvious form letters for people he's never met. And I called to make sure he was licensed as a social worker in New Jersey, and they said that they get lawyer calls about him from all over the country pretty much every day because of what he does. So it needs to be geographically reasonable. I'm not saying an out-of-state letter will never work. I'm saying if you have a tenant that's just moved into the area, an out-of-state letter makes sense. But if you have a tenant that's been in the area for the past 10 years, an out-of-state letter does not make that much sense. And it needs to be logical with regards to time. I usually say a year or 2 years because disabilities can be rolling. The tenant might no longer have the disability. In some cases, of course, that's not logical. If the tenant's blind, they're going to probably stay blind. But anxiety, some of these mental health related issues, they can resolve themselves, which means that you want to make sure that that letter or note is geographically reasonable and temporally reasonable.
I get the feeling you would not approve of my emotional support crocodile. Well.
I mean, I had a question. Somebody wanted a pig. Can a pig be an emotional support animal? My question was, well, how big is the pig? If the pig is cat-sized, probably.
Is it ex-husband sized?
Is it bacon?
Yeah.
And I will say, I think we're going pretty well on time, about halfway through, but I may speed up slightly. You should understand, especially if you're representing landlords, but also tenants, that although the law requires you to send a termination notice, usually it requires you to send one notice, and that sending multiple notices can sometimes cause you problems. If you send a notice to pay rent, and then you wait 4 days and send another notice to pay rent, and then you wait another 4 days and send another notice to pay rent, and then try to go to court on the first notice, the tenant may very well have a defense that you sent a later notice telling me I had more time to pay rent, and so I was relying on that last notice.
I tell my clients that subsequent notices invalidate previous notices. Right. So if you send the one that you send as many, like the collecting rent regime, like you can send as many letters and pay your rents and things that are red, that are on their doors. You can send as many of those warnings as you want until you send your final notice. That final notice, the 7-day notice to pay rent or vacate, that's it. That's the last thing that you need to put on a tenant's door.
Right. So just be aware, and I have seen cases, and there are cases reported around the country where the judge breaks down, was it reasonable for the tenant did the second notice give the tenant some reason to think the first notice was no longer viable? But I think that what you're saying is the safest route. That's
safest route. It's just send your 7-day notice as your last one. Switch your protocols. Don't send your 7-day notice first and then your badgering reminders. Send your badgering reminders and then your 7-day notice after. Because that should be something that you use sparingly. I mean, you should, you can certainly put up your 48 hours, your rent is due letters, all those great things. You can put as many of them up as you want, but once you send a 7-day letter, that's it. I like this one. Nothing in the Alabama Landlord Tenant Act tells you what happens or how to handle an occupied unit when the tenant dies while in possession. This has been a real just tricky area in my practice because tenants die in possession all the time, and there's no clear sort of policy or procedure for handling it that's given to you by statute. So this is why if you're advising landlords, you want your landlords to develop a policy or procedure for how they handle a unit when a tenant dies. You can think about putting in the application that the emergency contact is allowed access when the tenant dies. You can start putting your lease how you're going to handle it when a tenant dies. But there's nothing in state law that tells you what to do.
Yeah, I think what I've seen is, especially, 8 or 9 years ago, when someone died, the unit would just sit there for months because no one wanted to get rid of the property because they were afraid they'd get sued.
You've got your abandonment. I don't think either one of us in our top 10s talked about abandonment, which is kind of weird because that's a big problem. But you can have abandonment by death. I mean, you can, in theory, abandon something when you die. If utilities get discontinued, it's in fact abandoned at that point. But that's just another example, and you're laughing, but that's a round peg in a square hole. You're doing your best.
Yeah, sure.
Like, there's no, and my point in here is not what the result should be or what you should do, other than have a policy, put it in your lease what your policy is. My point is that there's just nothing out there.
Sure.
So your policy guess is as good as mine on how to handle it.
I wanted to point out both the landlords and tenants and people representing tenants that the records regarding tenants actually will follow them for a fair amount of time. As I mentioned earlier, there's a fair number of databases that collect information on evictions on tenants. A lot of tenants feel like if they move out, they weren't quote unquote evicted. It's not going to hurt them. If they pay their money afterward, that's going to fix everything, and no one's going to care. And what I hear is quite often for several years afterwards, including when people go to buy houses, they will look back at the evictions and see what happened, see if they didn't make payments, whatever. A lot of landlords won't rent to anybody who's had an eviction in the last couple of years.
That's one of the big concerns tenants have when they talk to me out in the hallway before court is, will this eviction be on my record? Or will this eviction be on my credit? And if I'm not pursuing a money judgment, I tell them, and I think correctly, that it's not going to be on their credit because it's not a judgment. I tell them that as far as their rental history goes, even if it's like an arrest, even if they're found not guilty, there's always a record of the arrest until, of course, the expungement statute passed. There's no sort of companion way to get rid of an eviction. So even if I file it, they pay in full, I dismiss it 2 days later, my landlord's been made whole, but that eviction is going to be on their record for years.
And even if, and I've seen this, that some attorneys have moved on to sealing records. It doesn't seal because the database that captured the eviction when it was filed quite often only reports that it was filed. And so they still correctly report that the case was filed, and even sealing records doesn't make it go away.
I mean, and the thing you're into is that's really a problem when an eviction's filed and the tenant wins. Because they have had an eviction that's going to impact their housing, even though they prevailed on the action. There's really no two ways about it. I always say that you can't unring a bell. I have in fact filed it.
Well, I think from a tenant standpoint, it is a thing to be aware of if you're advising tenants before an eviction is filed, that once it's filed, win or lose, it's going to hurt them. And also on the landlord side, knowing that once you filed it, it's going to make it harder if the tenant's getting ready to move out. You think they're legitimately going to be out in a week. You may throw a wrench in their plans and keep them as a guest for a while longer.
And the thing you also run into is one of the ways tenants I say can rehabilitate an eviction being on their record is if they have paid the balance. A letter from a landlord saying, yes, we've been made whole.
Mm-hmm.
It's been paid in full. And I think that rehabilitates a lot of housing situations.
And yeah, there's definitely times when we've told people to carry your orders with you, carry all your paperwork, but it's a pain.
Okay, my number 4 is the lease agreement that includes a right to purchase the property normally falls outside the protections of the Landlord and Tenant Act. So in the Act itself is the definition section. In the definition section, it says specifically excluded from the protections of this Act are tenancy or occupancy pursuant to a purchase contract. So what I'll see is, I saw a lot of this years ago, and I think people have gotten smart to it. I'll see a straight lease contract, but floating around somewhere there's a sales contract. The problem you've got is that the agreements, you can't execute agreements in a vacuum. Those agreements incorporate to each other, and that sales contract has an arbitration clause. Yeah. So people can really, when they do these, I always say if you're going to rent a house. If you're going to sell a house. Don't create that gray area because the law really just doesn't have a remedy for you at that point. The reason that evictions are dirt cheap and relatively quick is because the only right that you're terminating is a very minor right. It's the right to occupancy of a tenant. When you start talking about equity, or you see these lease purchase agreements where all on time payments, reduced purchase price, or where 500 of the rent is rent, the extra 150 is going towards a purchase price, well, you've given a tenant more rights than just mere occupancy, and a district court isn't designed to quash that right. So any kind of purchase interest is going to risk kicking you out of unlawful detainer court.
And I think what she knows and what I know is that, as we said at the very beginning, it takes a couple of months, a month to 2 months, to get someone out in an eviction. It's meant to make renting a viable option for landlords, to make it a quick. And if you're not under this act, though, if you get knocked out to the regular, if you're an ejectment case,
those take months, months and months and months, and they cost thousands of dollars. So when you have a tenant that wants to purchase the property, the appropriate response would be, come back to me when you've got a pre-approval letter and we'll talk. You don't want to do that at the outset. It's I've seen it be used by some tenants with sort of sub-rate credit. I've seen them use this purchase interest as a way to dodge and avoid being in the unlawful detainer. So, as long as when you're advising clients, you tell them that purchase interest has got to be worth it, worth risking an ejectment action, I usually say stay away from any kind of lease agreement that has a purchase interest attached to it.
I'll say at Legal Services, we love these because we know our clients will be living in that house for
a very long time.
Just as a basic rule, anytime you're representing a landlord or a tenant, if you're representing a landlord and your landlord is a public housing entity of any sort, if they're a tax credit property, whatever the deal is, there's going to be a lot of rules associated with that. There's going to be a whole body of federal law and some handbooks and some pamphlets, and it's so just be aware if you're an attorney for a landlord and approached by some sort of public housing or low-income housing of any sort. There's lots of different kinds. There's hundreds of kinds. Just be aware that the law is going to be substantially different. You're going to have to really educate yourself on what specific type of property that is, if you can figure it out, because sometimes it's even hard. They don't know. And if understand that if you are representing tenants, they're almost certainly going to have some additional rights. Right to grievance hearings, right to
informal meetings.
Informal meetings, review the evidence beforehand sometimes, and it's all depending on which type you're dealing with.
And I will reiterate that most of the time your client doesn't even know what type of subsidized housing they are. The person to talk to is usually the person that handles the accounting.
Sure. Yeah.
They're going to know what section of, because sometimes it's what section of the tax code that they were developed under. Proposed termination, the binder that HUD has on termination, we printed it out. It was 600 pages. I've got it on my bookshelf at the office. It's one of those things where trying to figure out what type it is and then what protections are provided is a real headache and hassle.
So I guess the advice would be, if you are going to represent landlords, if you're in for a penny, in for a pound, like you wouldn't want to represent a apartment complex with 4 units in public housing, because that's going to be a substantial amount of your time learning the law on those units.
Okay, in June, the Landlord and Tenant Act, for years and years and years and years, a tenant was only entitled to a 7 calendar day notice before a termination could happen. Matter of fact, they amended the rules of civil procedure, I believe, to make sure that we knew it was calendar. It was written calendar in about 6 places in the statute. They had really sort of hung their hat on it being a 7 calendar day notice. June the 1st went into effect that it is now 7 business days. The tenant has 7 business days within which to cure a monetary default. It is not defined in the statute what a business day is. So that's been really interesting. It doesn't say if it's, a 9 to 5 Monday through Friday, if it's, a banker's hours or a cosmetologist's hours, somebody in the service industry. It doesn't say whose business we're talking about. but it does in fact say now that it's 7 business day notice. What it did not change, though, are the non-curable defaults. Those are still, they did not write the word business in, so absent that, it's probably still a calendar day notice on the non-curable, the criminal activity defaults.
And do you see many landlords who didn't get the memo and are still using the old?
I mean, we, at our office, I went up and down the state teaching it. We handed out new ones. In June, there were a lot of evictions that our numbers for June were off because if it didn't say business, we weren't filing it. So now I think that the people that it's catching are the people who file evictions only every once in a while, the private landlords. Some judges are bouncing your evictions if the notice itself doesn't say business. They're just unilaterally deciding that that's not an appropriate termination letter unless it says business. But our rule in the office used to be, before this started happening, was as long as it didn't say calendar. If it just said 7 days, we were fine. But now some judges are saying it has to say 7 business days. I will tell you that I have been told through the grapevine that they're going to reach out to the legislature to change it back to calendar.
Boo.
Lame.
I mean,
Double lame.
Well, the thing you're into is I think you don't know what a business day is.
I think we can figure it out.
Is Confederate Memorial Day a business day?
Yeah, is Confederate Memorial Day a business day? What about...
Is the courthouse closed?
But it doesn't matter because this isn't their time within which to answer.
Yeah,
this is the time before...
Before I give you the answer, when was my client served and when do they have to do the 7 days?
So the thing you're into is like, well, what if your leasing office is open 7 days a week, 24 hours a day? What if you're always available? Or what if your leasing office is only open Tuesdays and Thursdays? When is a business day? What if we have another snow day? Does that count as a business day? Am I supposed to keep up with 67 counties worth of snow days?
Okay, counselor.
Sorry.
That's an excellent argument. I think we can leave it to the
10
people.
days. 10 days.
Would you agree to 14 calendar days? I'll take that. Just for the record, and we'll go ahead and split it up again because I think we're getting slightly behind. You can't lock a tenant out. You can't turn the water off. You can't turn the power off. You can't do anything to interfere with someone living there until you get a court order. I think most lawyers would know this. I think I've only had one lawyer in my whole time tell a landlord it was okay, and it was the case where it was his dad who was a lawyer representing his own father, which is a great idea.
Well, I have in commercial evictions, we'll have lockouts.
Oh, sure.
Those are fine. It's fine to do. So sometimes you'll see attorneys that practice in commercial evictions, and they think that they can do all sorts of crazy stuff in residential. And generally speaking, there's no the law disfavors self-help in residential settings. Late fees. Late fees are not designed to punish. They're supposed to be designed to be rationally related to the costs associated with late payments. So the increased time that your landlord is spending trying to collect the rent, the increased number of phone calls, going over there more often, that's what late fees are supposed to do. They're not supposed to just punish a tenant for the late payment. So I'm seeing more and more leases being redlined by judges on my late fees. I have some counties where a judge will only give 10% late fee no matter what the contract says. I have other counties where I can get late fees up to half the monthly rent, depending on what the contract says. It's wide, I know.
Which counties are those?
We're not going to talk about which counties those are, because we don't want you guys we don't want legal services to stop it. But late fees, when you're writing a lease contract, we just recently, in our lease product, capped it at 10%. Because you're in a situation where if your judge isn't going to enforce your contract anyway, all your late fees do is give your client sort of an artificially inflated bottom line figure. They think that they're going to collect late fees on late fees, that they're going to collect, that $10, $15, $20 a day accrual. They think that they're going to collect that. So when you're drafting these contracts, just keep the late fees reasonable.
Yeah, and I will say that I think does Jefferson County still have written into their administrative order that they're capped at 10%?
I think so. Limestone County, the closest county to us that I've seen do it, Limestone County caps it at 10%. Judge Huggins.
And this is more of an FYI because I think there's an area that affects or potentially affects landlords that not a lot of people talk about. Just like the Fair Housing, there's a federal Fair Credit Reporting Act, which can come back to bite landlords under certain circumstances. Basically, the FCRA requires that the big three credit bureaus maintain credit records appropriately, but it also requires that people called furnishers, which would be landlords oftentimes, who report information, report it accurately. And so I think the only thing I would tell attorneys and also potentially tenants attorneys, I have on occasion seen a landlord who thinks it's a good idea to put some crazy number on there as a method of collection. Because if you put on someone's credit record, they may eventually show up when they try to get a loan or something and fix it. I have seen times when it was, the rent was $600 a month, they were 3 months behind, and then you get it and it's $8,000, and you say, well, we ran the lease, or
they've put termination penalties on that. They've put property damage on that. The last tenant standing is always the tenant that has to replace the whole carpet, even if the carpet wasn't in great shape when the tenant got it. I try and caution my clients when they send those security deposit accounting letters to not do that. Not necessarily because of FCRA liability, just because you're going to open yourself up to a can of worms.
Well, and so if a tenant goes and files a complaint with the credit bureau, and then that letter gets sent to the landlord to confirm it, that may be the moment when you want to think about what you put on the report. How accurate is it? Is it reasonable? And because we both know there's at least one lawyer here locally who will accelerate the entire lease. If you rent for the first 2 weeks and you get evicted, he'll accelerate the next 11 months. I don't know that the judges let him do it anymore, but he used to get really large judgments, which I think could have potentially subjected you to liability under the FCRA.
Okay, acceptance of rent during an action normally terminates a landlord's right to evict. So this is not just when you give that 7 business day notice for failure to pay rent, any payment that you take after you give that business day notice, even if it's a partial payment, your notice is no longer any good. Once the eviction, what happens with that 7 business day notice is you are terminating the lease contract. You are saying you either have to pay rent or vacate. If you don't do either of those things, then this lease contract will terminate. That's why it's called an unlawful detainer action. The tenant's lease has already been terminated previously by your notice. Now they are unlawfully detaining their property because the lease has already been terminated. So if you accept money, you reform that legal agreement. So you're going to once the 7 business day notice is given, it's in for a penny, in for a pound. You're either evicting this tenant, in which case you cannot accept any more rent, or you're going to accept a partial, or you accept a full, in which case you cannot get your property back. The thing that I wanted to also highlight is this matters as well for conduct-based evictions. So if you have a tenant that you've given a conduct-based notice for, say a drug activity or unauthorized occupant, if you accept rent with knowledge that they're defaulting in that way after you've given that notice is no longer any good. You waive your right to evict based on that conduct-based violation.
And then do we have any questions, Holly?
There are a couple. The first one was notices to tenants to terminate tenancy, 7 days, 14 days, 10 days, and I think you pretty much covered that. And do you want to go ahead and do your number 1?
I'll do my number 1. Okay. There you go. My number 1, and this is more of a pet peeve for me working here at Legal Services. I don't think you've ever claimed this. Under Alabama law, a lease can be a written document, but that doesn't necessarily have to be a written document. The lease is the agreement between the tenant and the landlord that they can rent the property and live there. I don't know how many times and it's usually the landlords who lock somebody out. And I call and say, well, they're a tenant, and they say they don't have a lease. And I'll say, well, did they pay you rent? Yes. Well, there's an oral lease. No, they don't have a lease. I
have people who say, I'll have tenants that defend evictions by saying that they never signed the lease. And I'm sitting here and I'm like, well, But you live there, so why is that a defense?
So you're saying you had no right to be there at all?
Yeah, like, well, cool, that's my point, go.
We didn't talk about it, but there is the provision that says if either the landlord or the tenant doesn't sign the lease.
And if there's ratification, then it's good for a year. Yeah, oral leases, I had a judge that didn't believe there could be a such thing as an oral lease. Yeah. I was like, well, the whole point of the Landlord Tenant Act, all the sections about how to determine when rent is done and length of tenancy by basis of frequency of payment, like if there's no such thing as an oral lease, why is that in there? Mm-hmm. And that sort of got into thinking.
Yeah, I mean, clearly that was the purpose, and we didn't mention it early on. The Alabama Residential Landlord Tenant Act is based on the Uniform Landlord Tenant Act. It's been used all across the country, and one of the main purposes, well, one of them was to establish rights and remedies for both sides, and then the other thing was
it's a gap filler.
The gap fillers. That you have to, if you pay rent on the first, that's when your tenancy is from. I mean, it's I can't imagine practicing. I don't think you practiced before the new law. I didn't either. I can't imagine how miserable it must have been to try to figure out like what the rules were, and I bet you it was probably even.
It was probably like dealing with dead tenants. You just sort of made it up as you went along, I guess.
And waited until someone showed up to.
Yeah. So termination notices, failure to pay rent. This is conventional property, so these are non-subsidized properties. Failure to pay rent is 7 business days. All other lease violations, conduct-based violations, are 7 business days, except your criminal conduct. Your criminal conduct is 7 calendar days. Criminal conduct is drug activity, discharge of firearm not in self-defense, and assault not in self-defense. 14 days is still in the statute, I think, only for material misrepresentation of fact in a rental application. If your tenant lies, like they check the box that says they've never been evicted, you find when you go to Alec Court 6 pages of evictions, you can unilaterally give a non-curable lease violation that says you've lied to me on your rental application. You have, I believe it is still, that's the only one that's still 14 days for them to move. Your subsidized properties, you're either going to have a 30-day notice or I've seen people try and do a 7-day notice with a 10-day meeting. That's ridiculous. You're going to at least have, if you have that informal meeting requirement, it's going to have to at least be a 10-day notice. So.
Yeah. Were there any other questions?
There is one with reasonable accommodations. Who pays for the accommodations?
And non-subsidized properties and conventional properties, if they're making it, in that case, it would be a structural modification. If they're making a modification, the tenant has to pay for it, and the tenant has to restore the property to its original condition at the end of the leasehold.
Well, that's for like the physical reasonable accommodations. I mean, the other things like parking spots and,
I usually say if the tenant's going to make a modification and you as a landlord want to keep the modification at the end, that you should usually help pay for it. So if the tenant wants to put a grab bar in the shower and you want to keep that, so it's just fundamental kind of working out a price split or.
But the law says.
But the law says it's all on the tenant, yes.
Another interesting question, could you speak to federal protections for immigrants in a landlord-tenant relationship, such as someone who has applied for a green card but not received it yet?
I mean, I think they're going to be covered by the Fair Housing Act, regardless of immigration status, if they're being discriminated based on national origin. So you're going to have the FHA on your side. I don't necessarily know I can't remember if they overturned that portion of the Alabama law that said you.
It was enjoined. Alabama about 4 or 5 years ago passed an Arizona-style immigration bill where it criminalized renting to people who were here out of status. Resulted in a lot of fair housing complaints, a lot of testing that was done in this area, a lot of property managers that got in trouble for only asking for citizenship information from certain tenants versus all of their tenants. There was a couple of charges of discrimination based on that, and that's what caught Huntsville Utilities as well with FHA. But in terms of a broader sort of state-specific immigration protection, there's nothing here in Alabama for immigrants.
Well, and I see that our time has largely run out. It is 12:59. So I wanted to thank you so much for coming, Sarah.
Yeah, it was fun.
It was fun. I was afraid we'd get into a fight in the middle, but we made it through civilly, and so appreciate you being here.
We would have had better response, I imagine, if we had decided to do this with fisticuffs.
So again, thank you to everyone watching afar. Please fill out the survey afterwards. Let us know what you thought. Let us know next time if you think that
Fair housing might be worth doing.
Yeah, well, fair housing, or I'm always interested to see people come up with kind of random things on government benefits and all different sorts of stuff. But thank you for attending. Hope you all have a good weekend, and we will see you again next month. Thanks so much. Yes, hit the stop broadcasting. Is it?
No, I have to stop sharing screen. Where's the stop broadcasting?